All right, we're going to call the joint committee on the judiciary to order this morning. We've got a tight schedule. I know some of you folks have got to go on the Aurora Flight Sciences tour at 9:15. I was told that regardless of where we are this morning, if you're going on that tour, you've got to get to the bus for that one by 9:15 to make it. I don't think we'll exceed that time limit, but just being safe. I want to thank you on behalf of my co-chair, Senator Tom Willis, everyone else who's here, members of the judiciary committees on both sides. We have a lot of folks here who aren't even on judiciary, but showed up for this meeting, which we appreciate. We'll get to our speaker here in a moment, but the first thing we'll do is I'll recognize my co-chair for purposes of making a motion to approve our previous minutes.
Mr. Chairman, I move that we approve the minutes from the previous meeting.
All in favor of approving the minutes, please say aye.
Aye.
All opposed, say no. Minutes are approved. I should also say I talked to one of our staff members earlier. We do have a quorum, so for the record, that was established before we made the motion to approve the minutes. So we also have a quorum this morning. For our second order of business today, we will move straight to our speaker. I believe we have two speakers listed, but I think we may just have one today. Yeah, just Mr. Garner Marks. He's the General Counsel for the Department of Commerce. His subject matter this morning will be national overview and trends in state versus local broadband preemption. So we're going to keep that tight this morning. We don't have a whole lot of time, but we're going to stick strictly to preemption. Broadband in general, we know a lot of that fits in within the office or within the technology and infrastructure committees. We had a long meeting at the PSC or long hearing at the PSC a few weeks ago on pole attachments, for example. That may be something other committees look at, but for purposes of just trying to get a framework in place, get ready for broadband rollout, which we all hope happens sooner than later in West Virginia, preemption is part of what we have to look at. It's something I think that fits within the scheme of the judiciary committees on both sides. So on the preemption issue, we're going to take a look at that today and listen to what Mr. Marks has to say. If we have time for questions at the end, he's offered to answer them. So I will turn the floor over to you, Mr. Marks. Thank you for being here this morning.
Thank you. Thank you guys for having me. Hope you all are enjoying one of our, I think, our prettier state properties here this weekend. My name is Garner Marks. I don't think I had the pleasure of addressing the either Judiciary Committee during session. So for those of you who don't know me, I am Garner Marks. I'm General Counsel for the West Virginia Department of Commerce. And in that capacity, I also serve as General Counsel for the Economic Development and Tourism. Soon I'll be losing a business card, but maintaining the client with Economic Development coming back over under Commerce. But those are my areas that I work with. I've been with them for a number of years, and I'm here to talk about preemption, specifically with respect to broadband. Generally speaking, obviously the federal government and the Supremacy Clause give the federal government, the FCC, primacy over or preemption over things generally, but not dissimilar to that. The state has a fairly well recognized principle that dates back to 1915 and has been recently reinvigorated by the court, that political subdivisions are creatures of statute generally, and that they are created for governmental convenience, and that the legislature can modify, change, or withdraw any power granted by general law. So with that said, however, West Virginia doesn't have any law on the books right now that would preempt or prevent governmental ownership, municipal or county ownership of networks, internet service provider networks. There have been a number of projects that I've heard of, 2 or 3, that were possible projects in Huntington and South Charleston, and I believe there's a few others that have tried to get off the ground, but there are, to my knowledge, none that are municipally owned right now. The existence, or I guess lack thereof, of any sort of preemptive prohibition against municipal or county ownership of an ISP was viewed pretty favorably when when the state, the Office of Broadband, applied for the various federal grants that have become available over the last few years. Obviously, there are a number of federal programs that I'm sure many of you are aware of that are pouring a lot of money and have created a lot of interest in the expansion of broadband. And while, you know, it's the case that there is no law preventing the ownership of it, the department and the Office of Broadband kind of view ourselves as a tool for private entities to facilitate the expansion and provision of internet service provision. We don't really work to compete with the private sector. And our job is, you know, to create the most effective and efficient manner of transmission for the benefit of the public. So that said, however, where private industry does seek to partner with local and county governments, we're certainly happy to help facilitate that as best we can. While it's true that we have no prevention, and I'll touch on some of there are about 16 states across the country that have some level of preemption that either expressly or by operation of the law and economics of it do preempt the local ownership of internet service providers. But although we don't have those, we do have two sections in 31G, Article 6, Sections 1 and 2 speak specifically to preemption of local laws, local ordinances, specifically related, however, to the installation of broadband. Specifically, 31G 6.1, Section A speaks to specifically overrides or exempts any ordinance or any political subdivision relating to broadband service is preempted to the extent necessary in favor of such broadband installation. Similarly, Section B provides that any policy or agreement purporting to govern or control the installation of broadband equipment are to be strictly construed in favor of the installation and deployment of broadband. The Section B there kind of speaks more directly to private contracts and is focused more on the interpretation of HOA rules and those sorts of things that would hinder the ability to install something on the side of a building that's subject to an HOA rule. Similar to those two sections, Section 2 does the same thing. Effectively, it has an A and a B that relate specifically to pole attachments. And pole attachments are something that I'm sure you all have heard about and can be somewhat difficult at times, dealing with multiple companies and their easements and rights of way. But the addition of those preemptive sections have definitely helped spur things along. That said, we don't see a major push. We haven't received a major push for any sort of local preemption laws that would prohibit the ownership of ISPs by local or county governments. The more questions that we get are related to the compatible use statute. West Virginia's Broadband Enhancement and Expansion Policy Act authorizes broadband operators to contract with to construct and operate systems on easements that are dedicated for a compatible use, and the statute 31G 3.4F defines that as a public or private easement for gas, electric, telephone, or other utility transmission. So we get a lot more questions about that. These require that the broadband operator minimize any damages over those rights of way to trees, structures, or improvements. It requires that they indemnify the state or county or locality against any property damage or private injury. and it requires compensation for the rights of way owners. Nationally, there are about, as I said, there are about 16 states that have some level of preemption. I'm going to run through each of them and give a brief note about the idea of them, but generally their intent is twofold. First, to reduce what is often seen as unfair competition with private industry, the ability of a municipal government to subsidize internet service and compete with private industry, and second, a desire for a more normalized statewide regulatory environment to avoid difficulties, again, for private industry coming in, having to deal with different rules in different locations, and to just kind of create a more normalized regulatory scheme. That said, over the last 5 years, likely prompted by some broadband issues that arose during the pandemic and coming out of the pandemic, there have been 5 states that have completely gotten rid of their preemption laws. Arkansas, Washington, Colorado, and Minnesota have all removed their preemption laws. I'll go ahead and run through. Alabama is the first state that I'll touch on. Their law, it allows for local ownership, but it's pretty heavily restricted. It restricts the locality to their boundaries and requires that capital projects be funded only with network proceeds. They can't use other budgetary money. So that obviously, it puts a restriction on the ability of a locality to do that. Florida, again, it is allowed but heavily restricted. Unlike other municipal services that are offered, they impose a tax on this service, and it requires, interestingly, that the municipality has to be able to pay off the principal and interest and cover all operating expenses within 4 years in order to be eligible to create their own internet service provider. Louisiana, municipalities are required to hold a referendum, which can obviously slow things down or make things more difficult, and they are actually, interestingly, required to allow private entities to, they're not allowed to impose fees on private entities for use of their rights of ways, poles, and conduits if they do participate in their own program. Michigan has a requirement that you may only do it within the boundaries of your locality, and you have to put out, they would have to put out an RFP, and if they received more than 3, they're specifically disallowed. But if they do receive less than 3, they're allowed to, but they have to follow the provisions that they put out in their RFP. Missouri limits their, this one's kind of strange, actually. They limit their municipality's ability to lease telecom for non-internal purposes, but exempt from that internet type services. So there are a number of municipalities that provide free or subsidized internet service. The state of Montana is the next on the list of 16. They're limited to investing only in areas not offered by a private provider already, so they're preempted if there is service in the area. Nebraska is an easy one. They're pretty much fully disallowed, and Nevada is not dissimilar. It is banned for municipalities over 25,000 and counties over 55. North Carolina has a number of individual regulations that kind of make it less favorable and less economic. It limits the use of public funds it imposes costs and rates that are specific to municipal and local broadband service providers. It also requires a referendum, and it has a limit on the types of financing opportunities that a municipality can go through. Our neighbor Pennsylvania requires permission from the local providers prior to implementing your own internet service provider company. South Carolina again imposes a number of fees specific to state or local, or municipal or county ISPs that are not imposed upon private industry.
Wait,
Actually, for 1 second,
Yes.
apologize.
I got a note that the stream is maybe not working for this meeting. Does anyone know if that's true or not? I got a text from someone who said multiple folks can't access a meeting streaming online. Anybody from IT who knows if that's the case or not? Okay. All right. I apologize for interrupting you. We'll let
No
you-
problem.
Yeah.
Where was I? South Carolina, Tennessee, limits the ability of municipality or locality to those who already operate or own an electric utility. Texas has allows it in home rule cities, but they're only permitted to provide data services. They're not able to do direct telecommunication services. Utah, again, similarly, actually prohibits the retail operation of an ISP, but allows wholesale operation. But similarly to some of the others, they have some restrictions on the financing opportunities specifically related to bonds, the state or local's bonding ability for such a project. Another neighbor, Virginia, allows municipal electric utilities to provide internet, but not television or cable. And it requires rates be competitive or comparable to private sector costs. And finally, in our list of 16, Wisconsin allows for it, but requires local hearings and feasibility studies to be completed prior to the implementation. And similar to some of the other states, imposes certain fees or costs on the local or county provider that are not provided for on private industry. So you can see it's largely largely related to competition is the main thing. Competition with private industry and making sure that that's the end of it. I know we were just asked to speak about, Kelly's not here. I'm not the technical expert on implementation and installation, but happy to answer any questions you have, and I will do my best to answer them or write them down so I can get back to you.
Start with our co-chair. Any questions or comments for our presenter?
No, I'm good. I'll open it up to the group.
Yeah, any members of either joint judiciary committee, and then we'll move on just members at large after that, but any members of the committees have any questions for our presenter this morning? Delegate Count.
Delegate Kump, District 94, Falling Waters. I don't know if it's particularly germane to the topic of this issue, but it's been on my mind. In this implementation of these grants with his providers, I wonder what kind of administrative oversight on cost runs and profits and losses there is.
I can't speak to that, but I can have someone put something together.
Thank you.
Yeah, for you.
Members of the committee have questions for our presenter. Got to be at least a few out there from somebody. Let's open up to members at large. Any members of the legislature here this morning? Anyone want to ask Mr. Marks a question while we have him at the podium? I'll go ahead and ask a couple questions since no one else is. In the states that you said there were 5 states, I think you said since COVID that removed their preemption laws. In your research, were you able to tell why those states reversed course on that and took the preemption out? Did there seem to be a consistent theme, or were the reasons different, or could you tell at all why they did
Reasons
that?
were somewhat different. I mean, it was kind of viewed as a means of opening up competition as opposed to protecting against competition, I guess is one way of putting it. Allowing for state or local, county or local governments to get in the game.
Have you, in your research, were able to tell if there was more robust service in states that disallow preemption or more robust service in states that contain a preemption scheme in place? Were you able to tell that?
That's a very good question, and it's something that I wish I had done. Yeah.
Yeah. Along those same lines, the 5 states that removed their preemption statutory framework, if you know, did there appear to be an increase in internet service to the residents of those states? Did it actually work that way, or?
That would be a very good case study, and someone actually at Broadband may know better than I, and that's something I can definitely look into.
Yeah, I mean, not speaking for everyone here, but I would think everyone's goal here would be to provide the most service possible to as many residents of the state as West Virginia as we can. So I think the first question we would ask is which one of these frameworks seems to work better in terms of providing the most service. Now, again, even if you say, well, you get the most service this way, it's got to be the right kind of service, has to be affordable for residents, has to be reliable. So it's not just about providing the most service, it's also about those other issues as well. So I would like to be able to find out, maybe going forward, if you all were able to tell if a preemption framework seems to result in more and better service, if it's the same or different one way or the other. And then I guess my final question, maybe I prompted something from someone else, but have you seen that there's any possibility that sometimes private providers will come in after a local municipality, county, city, town, maybe has created a broadband service, and then the provider will come in and purchase that network possibly for less than it would have cost them to implement it themselves? That question makes sense to you?
It makes sense, and I could certainly see that being the case. I don't know of any specific instance of it, but it certainly makes sense that may happen. Yeah.
In the places where local municipalities or cities, counties, or towns do implement their own broadband service, are those available for sale to private entities? Can you tell from your research?
Like I said, there were some cities that require the wholesale provision, so they would sell through an ISP, basically lease their property to. There's also a few states that, while they don't operate, a few localities in these states that, while they don't operate an ISP based off of the preemption laws, they do lease conduit. So they've run conduit and made that piece of infrastructure available to ISPs. Again, probably likely at a benefit to the private provider.
I'm gonna keep asking questions if you guys don't stop me. So what about public-private partnerships? Does that ever exist with regard to the local municipalities, city, counties, or towns? They ever enter into joint ventures, for example, they do that with private entities or providers as well?
Yeah, and that has, I believe at least the Huntington project was a public-private partnership that was put together, and the Office of Broadband worked with them for some time. This was maybe about 2 years ago. I remember, maybe more than that actually, that I remember this first coming up. But like I said, the Office of Broadband is a tool that we're happy to help as best we can to implement the most effective and efficient means of broadband installation across the state.
Right, this will be a last question to ask. I'll put you on the spot a little bit with this one. Does the Office of Broadband or Commerce in general, if you can tell us, do you have a position or preference on a preemption framework, whether you want one at all, if you want one that maybe mirrors one of these other states, more or less restrictive either way? Can you tell us if your all's office has any preference on which way we would potentially go with this?
I don't think so. We're neutral, I think, on the idea. I think the current framework is working fine. The preemption laws that we do have that I referenced about installation are obviously beneficial and will help get fiber in the ground or hanging from poles, I think, quicker than it would have otherwise. And so that is certainly a benefit. But with respect to the local or county ownership of ISPs, I don't think that we are opposed to that, where it makes economic sense for everyone involved. So
in West Virginia now, we don't have a prohibition. For example, a local municipality could use general funds to create an ISP. Some states, you said they can only use network funds.
Yeah.
In West Virginia, a city or municipality, for example, could use general revenue to create an ISP.
there's nothing that would prohibit that at this time. Yeah.
Okay. All right. Any other questions from anybody in the room? Co-chair?
Yeah, I've got one. Are you aware with any of the case studies where a municipality or county looked at a satellite option as opposed to the broadband option?
Not to my knowledge. Nothing on the projects that I know of that have been floated in West Virginia. They've all been traditional broadband. Obviously, internet, the satellite internet has become more and more prevalent over time. So I'm not sure if any feasibility studies have been done on that, but that's certainly an interesting question.
And so before we let you go, is there anything you've seen, at least just with regard to our legal framework, our regulatory framework? We're not talking about the technical side of this, but is there anything you've seen where West Virginia is an outlier in a bad way that we need to look at, even outside of the preemption issue? Anything else we need to look at legislatively that sets us apart in a way that is a negative for the residents of the state with regard to broadband access?
No, I think not off the top of mind right now, but I think the work that we've done in the last couple of years since all of this federal money has become available to, in sections, 35G Article 6 sections, those certainly helped. We did have some roadblocks in the way, specifically related to pole attachments. That was a difficulty, but the PSC now has a better regulatory framework and process for adjudicating those issues that I think it's better than it was, definitely.
Last chance for questions from Mr. Marks. Mr. Marks, we appreciate you. I would ask that if we're able to communicate with you here in the near future, if you could tell us if you're able to find out if the preemption framework seems to create more or less robust service in other states.
Yeah.
That'd be great information to have. We'll let you go. We appreciate your presentation this morning. Everybody's going to Aurora. You're going to have time to make it. Thank goodness.
I kept it short just for you all.
Yeah. That's always smart. Yeah.
Yeah.
Less you say to us, the better most of the time. Yeah.
Thank you, guys.
Yeah, unless my co-chair has anything else, I'll recognize him for purposes of making a motion to adjourn this morning.
Mr. Chairman, I make a motion that we adjourn for the
All in
day.
favor, say aye. All opposed, say nay. Motion's adopted. Meeting's adjourned.